research on it.
Indiana uses 12, because they will use 12 too.
We have to get started with Section 8 because there is another speaker tonight, and I said I would release you by 5:15 so that you can go hear the speaker speak, but that means we've got to get moving here.
Who is the speaker?
Andrew Crumby, who is a lawyer down in Connecticut and owns the largest minority law firm in New England now. He graduated probably about 5 years ago, no more than that. He was in Connecticut law enforcement for many years as well. It's an interesting story. But listen, we got to look at Section 8 here. We've got a couple things to get out of the way. First, let me explain about the complaint that you need to draft. Of the fact pattern online, it is the one that says New Hampshire Chief. Because I was looking for it again today, and I found another one as well. If you've already done the other one, the Passpar one, then that's fine as well. But it should be, if you haven't done it, do the New Hampshire Chief one. And that needs to be submitted by Friday. Okay, that's why you have Thursday's class to do it. If you look online, we're giving you some additional links and stuff to look at. You know, at the end of the day, the complaint is a relatively straightforward item that you need to draft, but I want you to know how to do one because at some point, hopefully, you'll have the opportunity to litigate cases, and you need to plead them first before you get to go to court on them. So,
Their time?
Friday,
I was saying, is their time like 12 p.m.?
midnight.
Right there.
Huh?
Email?
Email's fine.
And no class Thursday?
No class Thursday, because that's what you're supposed to be, well, you could come here and draft it, or you could draft it some other time, but that's what the class Thursday is you're supposed to be doing, is drafting that complaint. Okay? So the fact pattern's pretty straightforward. There's some information online. I think you can put some forms up there online for you to take a look at, but that's due by the end of Friday, midnight. Which, by the way, even the filing process is slightly different in federal court than state court. And you ought to acquaint yourself with that just simply for your own edification as you start to think about making the transition from student to practice. But in federal court now, we file virtually everything electronically. And even the complaint would be filed electronically and the like. So you might want to look at that. But this week we're supposed to be talking about class actions, contracts to arbitrate, mediate, forum selection issues. Rule 23 deals with class actions. You know the definition: when there is a group too numerous for joinder who have been injured as a result of common questions of law or fact, that group gets to plead their claims collectively and the action is brought on behalf of some named representatives on behalf of the entire class of people who have been injured. The standard as to whether the case can proceed as a class, really the modern test has 5 whys to it. Numerosity, commonality, typicality. Which ones have I done so far now? Adequacy is one, and which one did we miss? Manageability, very good. Manageability, which is the most recent one we've added to that mix. And the class action generally is reserved for relatively smaller disputes. And that's what's interesting, actually. The article I just gave you ties both these issues together, as do some of these other cases for this week. But there are 2 very important cases that have come out very recently with respect to class actions, but even more importantly, the arbitration provisions within those different agreements. And what we've got is a slight tension, as you see in this article, about arbitration class action waiver rule unenforceable from the Massachusetts Supreme Judicial Court here. And what they talk about in that case is the Feeney case, Feeney versus Dell. And again, as we've talked about from time to time, you know, a lot of these online agreements have provisions within them that most people probably aren't aware of at all until they have a problem, but that's their own ignorance. But what they compare in this article is the Feeney case, which is a Mass case, versus the Concepcion case, which is versus AT&T, which is a federal case. And what we've got, at least think the article does a nice job distinguishing the cases. But on the federal level, we've got a very recent Supreme Court decision, which, again, the full decision is online if you want to see it, that was decided last spring, saying that the arbitration agreement is enforceable because the Federal Arbitration Agreement, Federal Arbitration Act significantly favors arbitration provisions so that disputes can be settled on a streamlined basis. But if you read the article I gave you, I think the provisions in that AT&T agreement, which required arbitration and didn't allow for class actions, were pretty fair on the whole and balanced to the consumer. If you look at the bottom of the first page of the article, that's not often the case. It's in fact very, very rare. But you got to remember, it's still probably likely. I think a lot of these clauses are, but in and of themselves, that doesn't make the argument successful. A lot of these arbitration and lack of class action provisions are likely to discourage some people from proceeding with their claims. But that was really the distinction here between Concepcion and Feeney, at least as our Supreme Court saw it, is that the arbitration provision in Dell doesn't provide any of those incentives for an employee, for the individual to encourage to pursue it that way. And what this article, again, and again, I think it's actually a pretty good article, even though it's relatively brief but to the point. What it makes reference to is the fact that in a lot of our employment agreements now, people are doing very similar things with respect to arbitration and waiving rights with respect to class actions and the like. And the question is, well, how will that weigh out as we go forward? So I think you should look at these cases, because we're going to look at the cases we're supposed to do as well. But these cases are the latest word on it. And the Supreme Court case, the AT&T case, also makes reference to the Discover Card case, which was a state court case in California, which was determined to be unconscionable at the time, and as an adhesion contract. And your U.S. Supreme Court case is actually, the AT&T case has now overruled that. But let's just take a look at some of these, the provisions within it, so that we can start to think about these issues. Because we've got Carnival Cruise Lines, we've got Guinness Harp, we've got the financial services industries, which we see represented by Merrill Lynch's case. And then we have General Electric and Circuit City. And what you should be able to pick up from that, and those cases are older, is that these types of agreements exist in an awful lot of cases. Let me ask you, just from the last question, really, the court talks about adhesion contracts in these recent cases, and in the past we've looked at fairness and that type of issue in deciding whether to enforce these agreements. With respect to Carnival Cruise Lines and Shoot, it is a take it or leave it proposition for them, isn't it? If you want to go on this cruise, you've got a provision here that requires you to go from one end of the country all the way to the other, virtually. Pretty much is. I'm not sure there's a greater distance in the continental United States. And isn't that likely to, at least in part, result in some people just simply walking away from their claims and not pursuing it? And does that just simply not matter as the Supreme Court does their analysis? Is, well, who cares?
I don't think that's fair.
You don't think it's fair? Does fair matter?
Well, I guess I don't care, but if you're doing a contract, you know, it should be fairly negotiated. For who's buying tickets or negotiating any terms?
But what do you mean by that, fee owner? I mean, if I'm one of these large companies, am I really supposed to negotiate individually with each of you? Because that sounds like a pretty inefficient way to do business too.
That's true, but when the average person is injured, and like in these people cases, they have to leave all their way in California and go all the way to Florida to litigate. I mean, the company could at least be a little bit fair, in my opinion, in having a forum that is more accessible. Instead of saying Florida, why not somewhere closer to California for people, for residents who live in period, so, you know, instead of saying everybody.
Everybody comes here where we're located, that makes it easy for us. Go ahead.
Well, I don't think they have to negotiate with everyone, but in the Carnival Cruise Line case, you didn't know there was an arbitration clause until you'd already bought the ticket. And there was no refund for the ticket if you didn't agree with those terms or conditions. So it really was take it or leave it. I think it is something that should be disclosed. You don't have to make individual case-by-case, you know, bases for these claims, but I think in the very least that should be something upfront, that you don't have to buy the ticket in order to know you're being subjected to that.
Well, let me ask you this. We all have cell phone agreements. How many of us have any idea where we're supposed to go if we've got a dispute, and not just where we go, what law might be used, or whether we get to go to court at all? Any of you read them with?
No.
You going to Delaware? You don't know. You just make it up. But you know it's not likely to be the courthouse down the street, right? And looking at AT&T, it's not likely to be court at all. But what it was interesting in this article, it said you could still sue them in small claims court, which is interesting that they would allow themselves to be sued in small claims court by all their consumers. That did strike me as, especially, by the way, small claims court in Massachusetts jurisdiction goes up to 7,000. That surprises me that they would be willing to be sued like that, but they did. Geneva, what were you going to say?
I was going to say I think it's fair. I think that the fact that the company is taking a risk of allowing you onto this cruise, then they're entitled to make a contract that works out better for them and for the rest of the passengers in the long run, because the ticket prices are lower.
So you really bought into that, huh?
Yep.
That Scott and I, we're going to pass all these savings along to the consumer,
Yeah.
all our legal fees. We're not going to send
I'm
it
a
off.
marketing major too.
We're not going to send it off to our shareholders and all the rest. You're going to see the benefit of reduced prices by us not having to face frivolous litigation throughout all of the courts in the country. Freddie, you buy that too?
Well, yeah, I was gonna say essentially the same thing. I think it's reasonable for them to, as long as, I think the biggest issue is, you know, is notice of that. I think it's reasonable for them to say, if you have any, you know, litigation, it's gonna happen in Florida, but giving notice to the purchaser of their ticket is the.
And when you say notice, does that really just mean as long as it's there? As long as
Right.
you could have been made aware?
I have a choice to go on a different cruise line or not buy the ticket.
Or not read the provision that they've given you?
Or, and you know, and like you said about the cell phones, it's kind of, it's you know or should have known. I mean, I should know if I am considering a lawsuit, that where I'm supposed to go.
So if you don't take the
If
time
I've agreed to that,
educate yourself, that's on you.
Yeah.
Right, is that right? So when you
Today-
click I
today's
accept,
world, you know,
you're accepting whatever's there. You could have known, you chose to remain ignorant. That's on you. It's not that you didn't know,
right.
it's that
I
you
mean,
choose.
almost every agreement, whether it's, you know, no matter what you do, it says, I agree to the terms, and they make you, you know, click
Initial
on
and-
that button,
right.
or initial, you know, to.
What about that?
So-
Have you rented cars? You haven't
Yeah.
really read the whole agreement, because I don't. They say, you're in the airport, you're rushed. Initial here, and over here, and here, right?
It's like when you buy a house. How many people have actually read the 50 pages of, you know?
Well, shouldn't you?
agreement? But you should.
That's a pretty big
Think
purchase,
about it.
Freddie.
Exactly.
That's
But,
why you hire a
I mean,
lawyer.
if you're
That's
being
why you
honest,
hire a
you either hire, if you're smart, you hire a lawyer who knows where to look for stuff. But at closing, I don't know, I've never done it. It would take a day if I actually wanted to read every page of everything they're having you sign at closing on a house.
So let me ask you that, because
Yeah.
it brings up a point. So when you're doing the closing, when you're the person representing that buyer, because we just decided they need lawyers, you've read the whole thing? Because you're going to explain every one of those terms?
You're responsible for it.
No, okay, but that's not the question I asked you. Are you going to explain every one of those terms?
If the client is questioning it.
What do I mean if the client questions it? You're there now. Someone's supposed to explain to me everything, right? So it's going to be you,
If they
correct?
hired me as an attorney, I'm explaining the
Everything.
terms. Well, I'm not reading them every page, but I'm
Whoa,
going to
whoa,
explain to
whoa!
them the
What do you mean
terms.
you say you're not reading me every page?
I'm not going to read the page to you, but if I'm your attorney and you've hired me,
You're gonna
represent
explain
you,
every
I'm
paragraph.
going to explain to you
Every
what
paragraph?
what you're signing, what it means. No, I'm not going to explain everything.
Huh?
We're gonna spend the whole evening at a closing then for it.
No,
That's
no,
what
I
I'm
said I'm not gonna explain every
Oh.
Whoa,
paragraph.
whoa,
I'm
wait a
gonna
minute, wait a minute.
explain-
I'm disagreeing with. So yeah, it might be inconvenient for you to educate me, and maybe you lowballed your fee. You don't think you have some obligation as my attorney to explain these most important documents that I might ever sign? No.
Do you explain to your client every time you file a piece of paperwork on their behalf, like what every paragraph in that paperwork is that you, it might be 100 pages of some discovery, do you sit down with them ahead of time?
I want to focus on the real estate issue, and I'll explain they would understand the steps we're taking, okay? But that's a little different because that's the obligations I'm doing and the like on their behalf. However, you're asking me to sign my name, and my partner's going to sign his or her name at the end of this document, and you should have told me what we're signing, no? Or are you just going to say, well, here's the mortgage, here's the note, pay your payments on time, not hurt people. Pay your payments on time, you won't have any problems.
No.
Huh?
Not in that mannerism.
So what are you going to tell? You're going to tell me what paragraph 15 means?
No.
I'm
No?
pretty sure that's what my lawyer did when I passed my paper.
Well, why shouldn't they? Isn't that what I'm paying them for, Laura? No?
Well, yeah, but I mean, you can probably leave out like the very basic, things. Like you don't have to read it word by word, but as long as you.
No, I'm not saying you have to read word by word, but let's write. Say the
Significant
mortgage document is what,
points,
4 to
that's
6 pages, right? Maybe 6 to 8 pages, right? Are you going to explain that to me, paragraph by paragraph?
Summarize it.
Well, wait a minute though. What are you doing? I'm not saying read it, because you could read it and I still don't
You
understand
can
what it
explain
says.
the significant parts of it.
Well, like significant parts means what?
Legal
Because
Parts that you
obligations.
feel.
aren't they all significant, or they wouldn't just be putting that crap in there, no?
I agree with this one.
So Stephanie, you're going to explain to your clients those documents.
I would want them to read it, and then I would go through it with them and like.
It's going to
make sure
take
that
you
they
6
understand.
reads the first time. No, I'm serious now.
Right.
It may take you 6 reads to figure out a paragraph.
Yeah, so if it's that difficult for me to understand, then of course I'm gonna go through it with them and make sure that they understand what they're signing, because at the end of the day, they're signing it, not me.
Why shouldn't you do that? Paragraph 1 means this. Paragraph 2 means this. 3, 4, 5, 6. This paragraph means you can't assign it without the permission. Flip it over. Boom, boom, boom. Isn't? If you just have me sign without giving me an explanation, because the banks may not give me the explanation. Someone pointed out that everyone wants to be done with this because we make money by time here, so we want to keep moving these people through, and maybe we lowball the fee. But you're the person that's supposed to make sure your client understands what's going on here. So I think that is your obligation,
I
isn't it?
think in this particular situation, and I'm not saying in every situation, but in this particular one, the people are hiring you for that exact purpose, because they don't want to sit down and read all of that, because they may not understand it.
Well, but I could
So-
read it and still don't understand it. That's why some people go to law school, I thought.
Right, so that is the precise reason that they're hiring you, so it is your obligation to go through every paragraph with them and explain it to them. I'm not saying in other legal matters you have to go ahead and explain everything to your client.
I agree.
But in that instance, you do, because that is the purpose they hired you.
And I do think this, I understand this, I'm pressure and concern, and I've been there with it, and just, here, ever sign this? Well, we're gonna walk through it. Because the obligation to insure, the fact that you can't assign it, the fact that payments have to be due, and if they're more than 15 calendar days late, you're gonna pay differently. And the fact is, if you miss a payment, they can take your house away, and then you'll pay all their costs and expenses and all the rest of it, right? I mean, there are some important things that they should understand that are in there, otherwise they wouldn't be signing 110 different documents. So, see, I think there's 2 things at work there. One of which is you're the new lawyer and worry a little bit about time, am I taking too long? But you just have to have a thick skin and say, I don't really care. Because either I'll explain it or you'll explain it, but someone's going to explain to them what that means that they're signing. And B, the other part of it I see at work is you don't know what it means yourself. And so you sort of gloss over it. And I think that, especially, you know, as a new lawyer, you may not have done a closing yet, and so the stack of documents is this thick. But you shouldn't be telling a client to sign documents that you don't know what they mean. So if you want to explain it simply, that's one thing, but if you don't know what all of it means, you shouldn't be sitting there unless you're going to read it and figure it out. And that's your choice. But here in these agreements, we're saying, well, the person's making a deliberate decision to be unaware. But in the situations where I have counsel, you're the one that's supposed to point these problems out to me. And so you just I mean, especially with respect to closings, there's a lot of different paperwork flying, and even in these agreements, there's a lot of different paperwork flying. We talked about the franchise relationships and things like that, right? I mean, you're the person paid to interpret them and tell them how bad this could get, because that's what we worry about, is the downside of all of this. So, back to the provisions at work here. Is it you must know, or is it you must be made aware of? Because that's how we get off this. Okay, so you signed all this stuff. Now you want to say you didn't understand, you didn't know, but that's sort of that willful blindness, isn't it? You could have. And you can't blame me. Maybe you can blame your attorney for not having explained the ramifications to you. Or maybe you can look in the mirror and say, listen, that rental car agreement, I should have read. When stuff goes bad, I recognize I should have read. But that's on me, not them, is it? Because the Shoots didn't know here till they got the actual ticket. But they still went on the ship, right? And they say they knew before they embarked on the ship. And frankly, for all of these cases, whether it's Circuit City or GE or the Merrill Lynch case, everyone knew that there were provisions in there with respect to arbitration and the like. And
They knew
it's,
after they purchased.
well,
They couldn't get
fair
it
enough. They
back.
knew after they purchased the ticket because they didn't have it beforehand. But they did know before they embarked on the ship.
Yeah, but I thought they couldn't get their money back.
Well, let me ask you that. Suppose they get their tickets. They now look at them. They still haven't gone on the ship, and they say, oh, we've got to go to Florida if there's any problem. Could they sue for a recovery of their tickets in Washington State? Could they argue that they're not bound by that provision since it wasn't made aware of them to them prior to receiving the ticket?
I don't think that's a reasonable expectation, though.
Well, how is that not a reasonable
Because-
expectation? You've added a significant new term to our agreement, haven't you? Go ahead.
I don't think it's reasonable to expect that a person would then go and, you know,
Sue them
spend
locally?
money, prior to going on the trip. I think they should have been shown that before purchasing the ticket. That way they had an option not to buy it. But here they bought it. They already have the mindset of going on vacation. And they're not going to say, wait, no, stop. I think I want to go to court instead and fight this. With, you kind of take the chance.
But,
and you-
okay, but taking the
hope
chance,
nothing
you say,
happens.
goodbye me, let's hope everything goes well.
Yes, but I think they should have been given that notice prior.
Ideally, yes, right? Ideally, they should have it before the purchase. But here, the court didn't care at all, and they don't really even look at the argument because at the end of the day, these folks say, we knew before we got on the ship. We were aware of that in advance. And look, all of these cases, your AT&T, how many of us really read the damn AT&T agreement? None of us, right? And you know what? We read it. And we say, oh, I don't like that clause. You think you're really getting the new phone and service with AT&T? You think there's any chance we're going to negotiate provisions of the individual contracts? Are they going to say, what's the guy at the store going to say? Look, take it or leave it. No one online is going to do anything of the same? I mean, the provisions have become so pervasive that the fact is that they become problematic. That's why we're seeing some friction between the FAA and both California, which is now gone by the wayside in its Discover Card case, and now the Massachusetts case with respect to Dell Computer. That Mass, at least presently, is saying, well, we see them as unenforceable and anti-consumer and against our public policy. Well, we'll see before we're done whether that decision is going to be the last word on it. So, as inequitable as it might have been, the Shoots stuck with having to go to Florida if they want to recover anything here.
Yes.
And that's just tough luck. So tell me what you would think that means for your, well, all of your agreements, all your online agreements. We see Dell Computer has them, they all have them. That means you're in for a penny, in for a pound. And you're stuck. Go ahead.
I agree with Fiona. I think that the provision's unfair. It's, the average consumer, I mean, is not gonna be, every contract you'd spend all day. I mean, reading the contract, that you have an expectation when the average person saves up to go on a trip. They have an expectation. They don't think that that they're gonna be injured through negligence of anyone. They're gonna go on the trip and have a good time and come back. And it's, gonna be, you know, I think that places like Carnival Cruise Lines, the corporations, they know that they're gonna win out by default on a lot of these, because somebody having to go to Florida, I know the shoots didn't prove that, but I think the average consumer is gonna be precluded from having their day in court.
I think it's likely that some people are going to look at the provision and say, oh, forget it, right? I mean, that just seems to be common sense, that if it's a relatively minor claim, the thought of going from Washington State to Miami, hiring counsel to pursue what might be, say, $1,000 claim, that claim is gone. It's just not going to happen. It's not cost effective. And you know what's interesting? You say they weren't able to prove the unfairness of the agreement. I included the terms of the actual ticket in the package, and some of you have seen it before when we looked at this case in Civ Pro. I mean, there are a number of provisions that really are disgraceful with respect to the loss. They're not responsible for any loss of life or personal injury under 4. No matter how much you lose, no matter what it's caused by, you don't get more than $500. All of your goods, all of your luggage, the value of the contents and the luggage doesn't exceed $100. I mean, if you look at the contract itself, it's grossly one-sided.
So in a contract like that, I'm assuming that recent accident up in Italy where the cruise ship was related to Carnival, they lost lives. They wouldn't be responsible for that because they put on a ticket?
I think the provision is likely contrary to public policy and therefore unenforceable. But the fact is that there may be limitations of their liability contained within it, and I don't know how you're going to necessarily resolve that. But we do know there's almost definitely some type of choice of law provision within that agreement, simply because they are likely doing business with passengers from all over the world. And I forget where that cruise ship left from or where it was returning to, but that may not even be a port anywhere in the United States, even though we know that they're United States citizens who likely booked that travel from here in order to take part in that ship. So, I mean, that's, at this point, really a nightmare of problems likely for where that litigation will go to. Not that difficult of a case on liability, frankly. But the rest of it, the procedural aspects of it become incredibly problematic.
I guess I'm one of the few on the other side, but I just think, even though you think it's a poor argument about the fact that
I don't think it's a poor argument. I'm cynical about the argument.
Okay, well then, I am going to argue for that side, because I would say that I don't think any company would ever start cruise ships and do that if they were subject to all of these people who get injured in any way, shape, or form, if they were going to be sued for millions of dollars in all over the United States, because a cruise ship isn't going to take that responsibility. They have customers from everywhere, and the amount of accidents that happen, I'm sure we don't even know about. And I do think it's quite easy to get injured on a cruise when there's water everywhere, and you tend to have some old people, you know, children running around and everything like that, that it's accident prone.
So we've got horribly unsafe conditions that exist. Why should we encourage them to make it safer? That's your argument?
It's not that we shouldn't encourage them to make it safer. It's just that, you know, people slip and fall. I mean, we could make everything absolutely safe by, you know, covering the parking lot so that no snow gets there and there's no ice. But I mean, we don't do that because everyone, you know, you take that upon yourself when you live in New England. It's going to snow, there's going to be ice. You're going to go on a cruise, it's going to be wet, and you got to be careful.
I know, but I mean, listen, I don't disagree with anything you've said, other than the notion that then it becomes a disincentive for them to try and make known dangerous conditions safer, even water on the deck. My guess is there must be something they could put on the deck that, because we know water's going to come, that make it less slippery.
I think they do. It's just that you can't prevent absolutely everything that you can't think is going to happen. Like in this case, other people were around her. She was apparently on a tour, and no one else fell, but she did. So, I mean, how else, if nobody else fell, why did she fall? You know what I mean? It's just, It's
So you think she's a fake?
I don't know, maybe she was fake, or maybe she was wearing high heels and she shouldn't have been, you know what I mean, you're going through a kitchen or whatever they were doing in a galley or something, but just in general, I think that you can't prevent every accident from happening, and they're just covering themselves, that if an accident is to happen, which I'm sure it will, and they can't do something to prevent it, then they shouldn't be getting sued everywhere when they're already going to be sued by
What about Fiona's argument that, for all intents and purposes, this injury has zero to do with Florida? They bought the ticket in Washington State for a cruise that was leaving from California off the West Coast.
Still think it's fine.
I know you still think it's fine, but there's still no level of unfairness to the consumer that should then invalidate a provision like this?
No, because I think that there are also a lot of other cruise lines they can go on. So this isn't, the only cruise in the entire world.
But you just said the economics are of it that every cruise line in the world that exists would have such a clause.
They should, but I don't know if they do.
Well, you said they would not start a cruise line but for a provision like this. You said they wouldn't exist.
I said, I think that
We have the tape of the clause.
if they didn't, then they're opening themselves up to getting sued.
Agreed. And listen, this is why we see the rush for companies to do this. It does give some certainty to where litigation will be brought, if at all. It gives them some certainty to how they're going to cover those litigation costs. And that's not insignificant these days for any major company, any small individual. And we're talking about hundreds of dollars an hour as reasonable. And a litigation expense is likely on any piece of civil litigation to run into the tens, if not hundreds of thousands of dollars. And then multiply that by a large-scale business that would have potential suits everywhere. The money isn't small. I would like to believe, too, that savings is passed on. I think some of it is, but I think some of it is also likely passed off to the shareholders. So I'm not so sure there is the equivalent benefit to the consumer where it does discourage some suits.
I would agree that it's a good mechanism to prevent frivolous lawsuits, but at the same time, I can't understand how the court said it's not an inconvenient forum for some, that's the part I can't get over. I understand that companies like this should employ those type of tactics and stuff to prevent the frivolous lawsuits that are out there, but for the court to say that it's not convenient is almost denial of the truth.
Well, yeah, I really don't. I mean, I do think they should say, well, we just don't care, because it's likely to result in less litigation and certainly fewer suits being filed simply because the cost is too much. When you've got to hire another set of counsel, and then really, even if we have a deposition, a simple deposition, which around here would be a relatively minor expense of, say, even for attorneys, the attorneys involved, maybe $3,000 with the stenographer's cost. Now we got to add not just the flight across, but travel time, which should also mean more money and everything else. I mean, it's an easily doubling of the cost, if not more than that. And also the inconvenience. I think it's likely to discourage it. I want to talk a little bit about, I gave you an article in the package, and it's related to the Merrill Lynch case. Federal judge with radical Pasco's Main Street. This is Judge Gertner. And now she has since left the bench she was our law day speaker last year, and she left the bench over the summer and now is teaching at Harvard. But a very, very unusual federal judge. And I'm wondering, when you do have a case before a federal court, as whoever had the Merrill Lynch case did, and Judge Gertner actually gave them some real chance to show that the arbitration provisions might not be fair or appropriate. Do you investigate the judge that you have? And how would you think you could do that? One of the books I can tell you about is downstairs in the library. There's this great book that's called The Almanac of the Federal Judiciary. And within that book, there is the background on every federal judge by both district court, appeals court, and then the Supreme Court. You don't have to worry about that for a while. But with respect to the district court, you want to know, and especially in federal court, remember your case is automatically assigned to that judge and it stays with that judge. You want to know who it is you're appearing before, right? You want to know what their background is. You want to know whether they what cases they've worked on. If they've been a judge for a period of time, you want to know what their decisions are. You want to start to look at this, because the fact is we can have different cases, but our mindset, for instance, with respect to summary judgment is often the same. Our mindset with how open we are to discovery is often the same. And the fact is, you might want to pitch and shape your arguments along the lines of what's been successful before this judge in the past. And so when we appear before a judge, it's actually significantly easier in the federal court to really get a full check on that judge to understand what we're looking at. But you do the same thing in the state, and the biggest tool you have for both now, but the Almanac of the Federal Judiciary is the best place to start for feds, but it's Westlaw searches, right? Let's look at the decisions the judge has reached and see what they've done, for instance, with discovery, what they've done with respect to summary judgment. I had one within the last year about they wanted a psychiatric exam of my client, and I wanted to limit how long that took and how many people could see him, because I wanted to limit the amount of adverse testimony they could bring against us. And so I did a search for the judge who was going to be hearing that in Superior Court to see what that judge did with the similar types of motions in the past, and shape part of the arguments around what those decisions were. You got to recognize that if you're going to be the advocate, it makes sense to start to think about what arguments are likely to be successful and what aren't. And we tend to, especially lawyers, tend to operate in a logical, somewhat consistent fashion. And so the research on who you're appearing before, and sometimes maybe I got to try and get out of this court and go somewhere else because I can see the handwriting on the wall. But you need to start to think about that, because I think from the Merrill Lynch case, they got very, very lucky, if you look at this decision, in getting Judge Gertner, who does have a radical past. I mean, she represented Catherine Powers and Susan Sachs in the 60s, and they were charged with killing a police officer and blowing up a courthouse. There aren't too many federal judges that you find, A, that are women, unfortunately, and B, that are relatively young. And so they got a good luck of the draw there, and I do think that makes a difference when you read this decision and thinking about her giving them some access to that information that might well prove that the entire arbitration process, at least in the financial services industry, is rigged against people. Because if you can't show that the process is rigged, the likelihood of being able to invalidate it is relatively low. The arbitrator's decision, it's not just encouraged that it go there under the FAA and the like, but in order to overturn the arbitrator's decision, it's very, 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 very difficult. You're going to have to make it rise to a level of arbitrary and capricious, and that's not likely that you're going to be able to prove that. So at the end of the day, the court is right in some of these decisions that it's much faster and it's much quicker, and you'll be done soon. And with this FAA in place, the courts are using it as a method to make sure that if you've agreed to arbitrate, you're going to go there. And remember, that waives some very important constitutional rights, but that's just the way it is. The Guinness-Hart versus Slits case, I think, is a very interesting case as well for you to look at. And there the question is, okay, so we agree to go to arbitration. Who gets to decide whether an injunction should issue under those circumstances? Should it be the arbitrator? And if so, is it similar, same five-part test that we've seen before? Or can someone go to court, get the injunction, and then stay the pendency of that case while the case ends up being arbitrated to a final decision? And the fact is that the court always has the authority to grant injunctive relief if it's appropriate. It could punt if it wanted to, but my guess is with a case like this, if I were writing these provisions now, I would be putting into the arbitration provision that even injunctive relief would be decided appropriately by the arbitrator and not a court. I actually think you could craft a clause 10 years after some of these cases, 20 years, 30 years after this one, where you could actually frame it such to almost oust the court of jurisdiction, period, until the arbitrator has ruled on the case. And if I were House counsel, I would do just that. Again, it's a streamlined, less costly process to the entity. And that, frankly, is what many companies are looking for, as Geneva points out, because it reduces the cost of doing business, and it also makes my cost of litigation that much more affordable and the like. So the trend is not going there, it's racing there, and it's not necessarily even a trend now, as you see, because we've got it in virtually every type of agreement imaginable. We close out today with the Circuit City case, which again is older as well, but that was one of the ones that is an employment case. And I think there is some interesting points between Circuit City, and we actually have a mass case related to both Circuit City and the GE case, because there's provisions now also with respect to these employment agreements and the like as to whether the agreement to waive certain claims and to arbitrate your employment disputes, how does that affect entities like the Mass Commission Against Discrimination and their ability to proceed, and EEOC. And so I think what you see from the standpoint of the GE case, that an individual, an employee, can waive their personal rights with respect to doing certain things under the terms of an employment agreement. But that doesn't oust the statutory bodies from investigating such claims on their own if they choose to, whether it's the EEOC or, and I don't have the case site with me, the Mass Commission Against Discrimination has found, the Superior Court has found the same thing in Massachusetts as well. So, fair or unfair really doesn't matter. If we think about, we may find the Carnival Cruise Line's decision unfair, but it is the law. We can look at these other ones, the AT&T case, and whether you feel it's fair or unfair, it doesn't really matter. The court doesn't care about what we think is fair or unfair, except there is language in this Mass case and in that federal case, the Concepcion case, that talks about they were looking at whether the process set up by way of that waiver of rights was in fact fair. And the Mass case talks about that might be the way of arguing it, at least with respect to businesses v. consumers, is the question about whether the process that's left over, and certainly the Dell case, Phoenix versus Dell case stands for that, whether the process left over is sufficient that it justifies the waiver of those rights. So I think I'd look very carefully at both the article and the new case that I gave you, and think about how those rights are affected with respect to these arbitration waiver of rights provisions that have become very prevalent now. So we have a speaker, so hopefully you'll enjoy the speaker. Thursday, you can either come to class and do it or do it somewhere else, but you need to submit the complaint based on the New Hampshire Chief Fact Patent that's online. Okay? It's on the website. I also made some copies of the fact patent, and I'll put them outside my office, but it's on the website as well, on the Remedies website for online resources. Say what? It's 2011. 2010 is a different fact patent. It should be NHG is the one you're looking for. And I had him double check this afternoon because I had trouble finding it myself.
Yeah, I'm not able to.
No, it's there. Go look now.
I am, yeah.
And the one that says draft complaint, he had it under section 7. He moved it to both. Now it should be under both section 7 and 8. Click on the link that says draft complaint, and it better be. Are you saying no? Is that you shaking your head?
I downloaded it yesterday instead.
No, Freddie's trying to do it right now. Does anyone have their computer open, huh?
It's bringing up 7,007.
It's bringing up a different.
Which one is it bringing up?
On the draft complaint.
What's it bringing up? The 2000, the Pacifier one?
Are you on his site or are you on the online course?
Yeah, but, okay,
Online courses, yeah.
It's on the online.
Online courses.
Alright. Okay, oh, it's not on your side, it's on the other
No, right. Check online courses. Hold on.
And it's under section
Does it
7.
snow on Thursday?
Student resource.
Yeah, you can work from home on this. Are you kidding? Wait, we're looking at a couple inches of snow, okay? We've had a light winter. Freddie, is it there?
Alright.
But someone who knows how to use that machine, do it.
It's under section 8.
It's not under 7 anymore, it's 8.
It's on the, it's.
Okay, so now it's under section 8,
Yeah.
and it says online, okay, and then you said draft complaint, it brings up the, you click on that, it brings up the right,
Yes.
okay. It says
It now says
2012 New
2012.
Hampshire chief, right?
Yep.
You got it over there, Freddie?
Yeah.
Okay, good.
Good.
Okay, so now we're all on the same page, thank God.
Section
That's not your fault, because I had trouble finding it earlier.